Please be seated. Thank you, Mr. Poynter.
Now, Mr. Poynter, where we were just before lunch is I had taken you to this internal audit plan for 2015 to 2017, which is CRW.702.001.2087, taking you to section 1 and section 2. Just wait for that to come up on the screen. And then if we go to section 4, which is at page 2271, this is a section called Audit Profiles, which gives you some information about what the audit covers. And at 2273, see International Commission Business, if we just cursor down, please. And I'll just give you a moment to read that. Tell me when you're ready for my question.
Yep.
Would you agree that that's in general terms and doesn't inform you in any detailed way about the content, purpose or robustness of the audit?
Just ask the question again.
Would you agree that that does not inform you as a director in any detailed way about the content, purpose or robustness of the audit?
I haven't formed a view now or then. It seems to me to be outlining what is planned, and so I guess one would wait for the outcome of that audit to determine its adequacy.
Well, you don't determine the adequacy of an audit by the results, but rather understanding what the process of audit is. Would you agree?
No. You're saying you don't determine whether an audit was successful when you've got the result of the audit.
You need to understand something about what the controls were and how they were tested in order to understand whether or not an audit will be effective. Would you agree with that?
Yes.
Right. Now, if we go back to page 2271. You see at the top there, prefatory words, it says in the second sentence, detailed scope statements will be developed prior to the commencement of each audit where appropriate.
Yes.
Did you ever see any detailed scope statements?
I can't recall.
Did you ever ask for any detailed scope statements?
Not that I can recall.
So if we come back to your witness statement at paragraph 77, I think it is. And where you are referring to the audit ratings as being satisfactory, good and good in different years, are you able to explain what basis or what controls were applied and how the controls were tested in order to achieve those ratings?
No, all I was in receipt of was the reporting from, internal audit and its rating.
And would you accept that it's a governance failure on your part not to have paid closer attention and scrutinised the nature of the internal audit plan and how it was executed?
No, not at all.
We go to paragraph 78 on page 0020, yes, of your witness statement. Paragraph 78, you say until July 2019, don't recall ever being provided with any information from management which caused you concern about the arrangements that the Crown Group had with junket operators. You were, however, aware from media reports that there were some concerns, didn't you?
Yes.
You reference at paragraph 135 of your witness statement the Four Corners program in 2014. So you were aware from that there were concerns raised about junket operations.
Indeed.
And you say in paragraph 135 you don't recall watching the program, but you were certainly aware of it at the time in 2014 that that program had been aired.
Indeed.
And the content of the program.
Well, having not watched it, I'm aware of the overall content.
Yeah. And was that brought to your attention by management of Perth Casino, that program and its
I
content?
can't recall, given that 7 years ago.
And what did you do in terms of governance and oversight of the Perth Casino in response to that program?
I recall subsequently being told that there was at least one inquiry, I'm not sure whether it was ILGA or the VCGLR, looking into this, and in fact, I'm pretty sure that there were no concerns raised as a result of those, whichever inquiry it was.
What about Burswood Limited investigating the situation in respect of Perth Casino as a response to the 2014 Four Corners program?
As I said at the outset, Burswood Limited is a company in the chain of the group, and my view would be, and it still is, that that's a company-wide risk and a company-wide issue. Clearly there was concern at the local level, but the response to it was seen to be, then and in my view now, most appropriately conducted by the board of the company at CRL level, and indeed with reference to the risk committee.
So did you satisfy yourself in 2014, after this program was aired, that the CRL board was investigating issues to do with junket tours to Perth Casino?
I don't specifically recall, but again, the chair of the company was sitting on the board to which you refer, and I would have, I don't recall a specific conversation, raised this issue with them and been satisfied that their response, either not feeling that they were fairly treated or indeed responding to other regulators' response to the article, on top of the issue.
Well, I want to take you to this document, CRL.639.001.0334_R, minutes of the ERCC of the 19th of May 2015, and if we go to page 344, under that heading, AML CTF update, chairman, that's the chairman of the committee, advised the committee, as a result of Crown Perth's decision to allow junket operators to be in a company name, changes to Crown Perth program were necessary, and it goes on. Do you recall this change where at Crown Perth, Perth Casino, junket operators were allowed to be in a company name?
No, I don't specifically.
Don't recall whether that was a decision made at board level?
I don't recall it being a decision made at board level.
Looking at it now, is it a decision that should have been made at board level and not at executive level, in your opinion?
What I don't have here is the overlay of whatever CRL had to say about this. So that would inform my answer.
Well, why?
Well, because as I said, it's the purview of the overall group, which has the power to direct and is in fact in charge of the company and through its committees to determine these sort of matters, in my view. And then, as I've said before, if there are concerns raised by them that specifically relate to the operation of Burswood Limited, then I would take action. But none of that happened.
You'd accept, looking at it now, that to allow junket tours to operate through a company name rather than an individual might increase the risk that the junket tours could be used as a vehicle for money laundering?
It might, and my response would be, what was standard industry practice? Because I'm confident the standard industry practice was to allow that. So as a director, if the company on which I'm associated, and I don't know this for sure, but I'm kind of led to believe it to be the case, that if the company is acting outside of standard industry practice, that would cause a concern. I'm told that this was standard industry practice. across the casino industry in the region. So that would give me comfort that it's not something to be concerned about.
Even if you looked at it and thought, oh, that looks like it could increase AML risk.
Well, again, all I do is I say I'm sitting in this particular place. I'm relying on other people, management and other board members, committee members elsewhere. I'm looking at the overall industry and I'm saying, does this give me cause for specific concern? I'm saying no, it didn't. Subsequently, years later, it would appear that this change may well have made it easier for that to happen. But at the time, I had no reason to expect that it would.
You were aware, weren't you, of the repeal of regulations in 2010 requiring GWC to approve junket operators?
I'm aware of that, but more recently.
So you weren't aware at the time?
Well, I don't recall, being 11 years ago, I don't recall that specifically. So I have to say that I remember it vaguely, but I've subsequently made myself aware of it in more
Can't
specific.
remember whether at the time you did or did not support that repeal?
Not off the top of my head, no.
Or whether or not you considered that the approval process provided an extra layer of risk mitigation in relation to AML and criminal infiltration?
So again, I would imagine, and I guess the records will show, that the respective parties inside the Crown Group would have been liaising with GWC, and there would have been agreement reached that GWC as a regulator would have been comfortable with the outcome. Again, I was given no reason to believe that that wasn't the case, then or subsequently.
All right, now, if we go to CRL.506.007.8870, and we go to page 8879, here, this is a report, part of a report to the Crown Resorts Limited Board on the 30th of July 2019 when you were a member of CRL, the CRL board.
I'm just trying to remember whether that was the meeting when I was in the United States.
In any event, you recall this report?
Yes.
Yeah. And this is some information, amongst other information, that the board was provided regarding material referenced in a 60 Minutes program about the Sun City junket operated by Mr. Chow. See that?
Yes.
If we go to page 8880, what's learnt there is that the media reports suggested that Mr. Chow was formerly a member of a triad in Macau, that he was accused of being related to a Chinese triad, and that allegation had apparently come from the US government in 2012. There was an allegation that he indirectly benefited from US $80 million stolen from the Bangladesh Central Bank in February 2016. And then if we go to your witness statement, paragraph 85 on page 0022, you say, after reviewing the content of the internal report, which included the passage that I've just taken you to, and hearing representations from management at the board meeting, although you were concerned by the media allegations, I recall I was comforted by the fact that at least one of the junket operators, and that's Sun City, to whom I've just referred, continued to be licensed in Queensland and continued to operate in Star Casino. So is your position that despite those adverse media reports, which I took you to a moment ago, you were prepared to refute the 60 Minutes program allegations without further investigation because this chap continued to be licensed in Queensland and operated at Star Casino?
So my specific recollections around this was we were all concerned about the allegations. We were told both internally or in an internal report and at the time of the meeting that a very substantial number of the junket operators, not just Sun City, were operating at Star and in some cases in a much, much more material way. We were also told that the Queensland Government had licensed Sun City and that Border Force had not barred any of the people associated from entering the country. At the same time, there were concerns and there were, I think, one or more committees or there was a brand committee. There was also a resolution at that time to very much look into the operation of junkets and the veracity of the accusations that were made. And I recall there were 3 or 4 external parties engaged around about this time and going forward to have a look at this whole situation. So I'm not talking about refuting it. I said I was comforted by the fact that Crown, in fact, was not the only operator dealing with this particular company and that we were taking steps to look into the accusations in more detail.
But shouldn't your position to have been to stop all dealings with this company until the investigation was complete? An investigation by Crown Group into these people?
Well, again, I'm not sure. Did Star City stop dealing with them? Because obviously what we're talking about is we're acting on behalf of shareholders. So, this is the great tension between, the whole situation where you suddenly decide that you're not going to deal with a junket or any junkets or any VIP, but all your competitors agree to keep doing it, right? So you open yourself up to an accusation by shareholders that you're not acting in their interests. So it's not black and white.
Well, what you're saying there is that you prefer the interests of shareholders and profits over the responsibilities that you have to operate a licence in a socially responsible and lawful way.
With respect, I object to that question. That was not what...
Wait, Mr.
That's
Boyne.
not what I said, sorry.
Sorry. Wait, Mr. Boyne. Yeah.
Yes, I object to the question put in that way. It was not what the witness said at all. It is significant embellishment and it should be rephrased properly in accordance with what the answers were.
Rephrase the question, please, Ms. Kane.
Please, Mr. Commissioner. So you refer there to shareholders, right? The tension between shareholders and investigating potentially unlawful conduct by a junket tour operator.
Yes.
Yeah. And the tension you describe is because shareholders expect you to generate profits. Is that right?
We have to act in the best interest of shareholders, which takes into account a myriad of things, which has to do with the value, creation or maintenance of the business, offset by and including all the social and other regulatory requirements.
Well, what social requirements are you referring to there?
Well, a social licence to operate, doing the right thing. Right. So, but in a competitive environment, and this is what I was trying to say, you open yourself up to an accusation by shareholders in this highly litigious world of class actions to have taken precipitous action prejudicial to the shareholders' interest. And it's one of the things that directors need to consider. Over time, over the period from 30 July 19 to towards the end of 20, there was increasing pressure on the company, if you like, about this whole issue, sort of culminating in an agreement in mid-20 to cease any junket operators initially until 30 June 21 and then subsequently permanently. So it's not as if the company wasn't aware that this was a major concern. And again, using the analogy about shareholders' interests, in making a decision not to continue with junkets, the board needed to be cognisant of the shareholders' interest. And I think I'm quoted somewhere, might have been in Bergen, as saying the risk-reward relationship going forward with junkets became weighted against wanting to continue for commercial reasons because of the overlying social ramifications and regulatory ramifications.
What are the social ramifications you're referring to?
Well, I'm talking about social licence to operate. In other words, the reputation of the company. Now, this is at a time when there are a myriad, I think 4 separate external reviews into dealing with junkets and AML.
Did you convey the information about Mr Chow and Sun City Junkets that I took you to in that internal report of 2019 to the board?
I didn't need to do that because they were aware of it, bearing in mind again that the chairman of the company chaired Burswood Limited.
Did you raise with the Burswood Limited board whether or not the Sun City Junket should be permitted to operate at Perth Casino?
Not specifically.
Would you agree that the level of oversight that you provided in relation to junket operations to the Perth Casino, such as that was a failure of proper corporate governance on your behalf?
No, I don't.
Can I talk to you about communications with the GWC? At paragraph 169 of your witness statement at page 0043. 169, page 0043. You talk about the licensee having primary responsibility for communicating with GWC, that's Burswood nominees. That was your position?
Correct.
Yeah. And that they had been given general authority to do so by Burswood Limited, that's your board?
Well, amongst others.
Well, you say Burswood Limited and the licensee.
Yes.
And that was obviously, though, subject to some limits, wasn't it, that general authority? Specifically the limits you set out at 171.
Indeed.
So you say if there was a material issue, it had to be escalated to the Burswood board.
Correct.
For the Burswood board to monitor how communications, the content of communications to GWC about that issue?
So I used the analogy earlier about APRA as it might relate to an individual board member of a listed bank, and indeed more specifically about something like Bank West, which is probably the most analogous. So APRA would not, in normal circumstances, be dealing with a non-exec director of a bank. It would deal with chair of audit, the CEO, the chairman of the company. So I had no reason to expect or suspect that any of the relationships going on between nominees and the members of that board with GWC was of concern. And as it turned out, subsequently, there was no reason to be concerned about that.
You're aware of presentations that were made by, I'll use this generic expression, Crown Management to GWC in August 2019
Yes,
and October 2020,
yes,
and PowerPoint presentations that were provided to GWC in each of those meetings. You recall those?
yes, I do.
Were you apprised of what the Crown Management was going to say to GWC before those presentations were made?
I can't recall whether we saw it before or after, but I've subsequently seen it for sure.
Should you not have not only seen it before it was communicated to GWC but approved it?
No, as I said, are you saying that as me as an individual non-exec, non-chair of the company, or the board itself?
Member of the board.
Right. Well, as a member of the board, as I said, I relied on the fact that the chairman of the company was sitting as the chair of the company that I was the director of, and indeed there were various other people in management. And again, at that stage was no issues, red flags raised with me that the material was a problem.
Well, you didn't know if you weren't looking at it ahead of time.
Well, as I said, I'm trying to remember when I became aware of that presentation.
Well, just looking back now, acknowledging that your memory isn't perfect about that, but looking back now with hindsight and remembering that in August 2019 and October 2020, basically in the thick of the media allegations and the Bergen inquiry, surely any communication to GWC about the content of those very serious matters ought to have been the subject of prior approval by the Burswood Limited board. Would you agree?
No, I don't agree with that. I think they should have been subject to prior approval by Crown as head co.
Now, in August 2020, there was a decision made to suspend junkets. That was a resolution of the board of CRL. You recall that?
Yes.
Did Burswood Limited board also consider whether or not to resolve to suspend junkets?
As I understand it, yes. I think it's reflected in the minutes.
And it considered that it was necessary for it to make a resolution separate from and in addition to the CRL resolution.
For completeness.
You give some evidence about what everyone calls the China arrests at paragraph 79 through to 82 of your witness statement. This is at pages 0020 to 0021, which you recall occurred in about October 2016.
Correct.
And you refer to the December 2016 board meeting a couple of months later. In paragraph 80, do I understand this correctly, your evidence at 80, that you understood that you were effectively being advised by management to do nothing in the immediate aftermath of the detention of the employees, to just wait?
There was a significant amount of discussion about this at the time, and I think the company was shocked and disappointed that its employees had been detained. It maintained, and still I think to this day maintains, that there was no proven breaking of the law. But what actually happened was the employees pleaded guilty to be released. There was obviously then great, introspection about the operations in China, and from that time on, the amount of business coming out of mainland China fell away dramatically because of the heightened risks. So it wasn't that we were being told to do nothing, it was that none of the employees in question were employed by the company I was a director of, and we were, it's an example of this flow of information down from CRL to a subsidiary board, because there are, and clearly were, reputational impacts.
Did you, as a director of Burswood Limited, press vigorously to understand from management how the arrests had come about?
Absolutely. There was a significant amount of discussion around this time, not necessarily always in under the guise of the board meetings, about how this could have happened.
Did you ask for a briefing paper?
Not a briefing paper per se, but I got a fairly detailed verbal report
From?
Mr. Felsted.
Were you concerned about the effect of the arrests upon Perth Casino's reputation in the eyes of the West Australian public?
Yes, indeed.
What did you do about that?
Specifically, I guess the question I would ask back, what could have I done? So we actually spent some time talking to Mr. Felsted. It was a moving feast at this stage, and there was a lot of work being done at group level to get the people released, and it was a very difficult time. We were monitoring that because none of the people were our employees, and there wasn't much more we could do other than make ourselves aware of what the company was doing to try and get the people released and not have it happen again.
In terms of the confidence that the West Australian public had about the operations of the Perth Casino, did you take any steps to reassure the West Australian public about
Not
the Perth Casino
specifically,
operations?
and I think people had a general level of concern, but I don't know that it actually suddenly caused a great diminution of activity at the casino in Perth because everyone was concerned about it.
Did you consider in your role as a director of Burswood Limited that you had some responsibility to make sure that the regulator was properly apprised of what had happened?
I was not a director of the company that held the licence. So again, I would say that the people who were on that board, and indeed up into risk at CRL, would have been the people primarily responsible for allaying any concerns.
Were you aware that up until the point of the China arrests in October 2016, the management of Perth Casino were considering rolling out to Perth the China Union Pay Card or CUP process that was being utilised at Crown Melbourne?
It was being utilised at Crown Melbourne and Star, and I think that was the main reason it was introduced to Melbourne, because it was very actively being used at Star. I don't specifically recall the discussion about rolling it out in Perth. I'm pretty confident it never was.
I'm not suggesting to you that it was. I'm asking whether or not you were aware that Perth management were considering rolling it out.
I don't have any specific recollection of that.
Or do you have any general recollection?
No, I don't.
Can I talk to you about harm minimisation now? Between paragraphs 152 and 161 of your witness statement, that's pages 0038 to 0041, you give some evidence about the topic which you describe there as problem gambling. Is it your position that the board of Burswood Limited did not have any responsibility for developing the framework with respect to responsible gambling that you describe at paragraph 152 of your witness statement?
So paragraph 153 and 154 relate to the subcommittee or the committee of CRL, chaired by Professor Horvath, the former Chief Medical Officer. I took great comfort that he and his fellow committee members were very much on top of this as an issue, that was being brought down to, I think I'm not sure exactly what it was called, but the equivalent responsible gaming committee of Burswood nominees. So this was something that was regularly discussed at board meetings and was, an issue of concern that the whole company wanted to make sure it was doing as much as it could.
So I'll just come back to my question. Did you understand the board of Burswood Limited to have any responsibility for developing that responsible gaming framework?
Not directly, no.
Or indirectly?
Indirectly to monitor and satisfy itself that the framework was appropriate.
So did it have a responsibility to approve the framework?
I can't recall whether it had a responsibility to approve it. It did approve it.
And did it have a responsibility to oversee that the framework was implemented properly and appropriately at Perth Casino?
It had a responsibility to oversee the implementation and satisfy itself.
And to then check that the framework was fit for purpose at Perth Casino?
Well, I guess it's all part of it. As I said, these things came up regularly, as you can see in 155. The ratings are good, low risk, excellent, good, through 2019. So 13 through 19, there was never worse than a good rating.
Well, these are the internal audit reports again, aren't they?
But they have to do with responsible gaming.
Yes.
So again, as a non-exec director, I'm taking these data points that are given me and I'm satisfying myself to the extent I can, because I'm using that with other things that are coming across my desk, that the company is on top of these issues.
But the internal audit reports, again, you never looked behind the rating to say, well, how was this audit set up? What were the controls that were tested? And how robust was that testing?
I relied on management and my fellow non-independent directors, i.e. management of the company, to be across all of those issues, including, as I said, right up to the Responsible Gaming Committee chaired by Professor Horvath. And I think that that was reasonable in the circumstances because there were a lot of people focused on it.
Paragraph 160, that's 60 at page 0041, you refer to Burswood Limited being involved in a number of initiatives to promote responsible gambling. You mentioned there too the annual West Australian Responsible Gaming Awareness Week and working with the PGSSC. What others, to your knowledge, besides the two that you've mentioned there, were initiatives?
I'm not sure of others.
Did the Burswood Limited Board ever review the effectiveness of the Problem Gambling Support Services Committee?
Not that I'm aware.
Did the Board ever consider whether that committee was properly funded?
No, not specifically.
Did it ever consider whether Perth Casino was making a sufficient contribution to that committee?
Not specifically.
Would you accept that that was a governance failure on the part of the Burswood Limited Board in failing to do those things?
No, I don't.
Would you agree with the proposition that an effective harm minimisation framework needs to be premised on robust research about how gambling causes harm and the type of harm it causes?
Could you ask the question again?
Would you agree with the proposition that an effective harm minimisation framework needs to be premised on robust research about how gambling causes harm and the type of harm it causes?
Yes.
As a director of Burswood Limited, did you at any time inquire as to whether Crown Resorts Limited's framework was based on any research?
I can't recall asking any specific questions at that time about that specific matter. I would have and still would claim to take comfort from the fact that people more qualified than me with more capacity to implement were managing the issue of problem gambling.
Did it ever occur to you in the 16 or so years you were a director of Burswood Limited that you should require Perth Casino Management to undertake research about how gambling causes harm and the type of harm it causes, specifically with respect to the situation in Western Australia and at the Perth Casino?
Not specifically as a director of Burswood Limited.
Well, what about generally as somebody
No,
involved in the...
no,
I'll just finish the
I
question.
didn't see that
I'll
was
just
my
finish the
role
question.
because there
Mr.
were...
Quentin, I've just got to finish the question. In your role as somebody involved generally with the Crown Group's operations, do you think that was your responsibility to make that suggestion?
No.
And did you at any time, as a director of Burswood Limited, or more generally as someone involved in the Crown Group's operations, inquire of management and seek reassurance as to whether advertising, promotions and the marketing of gambling to Perth Casino patrons was consistent or inconsistent with responsible service of gambling?
No.
Do you agree with hindsight that that is something you should have done?
No.
Can I turn to EGM specifically? You mention at paragraph 162, that's page 0041 of your witness statement, your understanding in your role as a director of Burswood Limited that the EGM business was highly regulated with a high value turnover. On that last point, you understood it to be a very profitable part of the Perth Casino gaming business, didn't you?
Yes.
And the highly regulated part you understood to be arising from the poker machine ban in Western Australia, is that right? And did you understand that the ban on poker machines related to the harmful effects of those machines?
To me, it was always a bit of a nuance, the difference between spinning reel poking machine and an EGM machine. But I accept that there was a concern that poker machines per se did harm.
And EGMs didn't?
Well, given that they're generically similar, they're not identical, and they have somewhat different requirements in terms of player input, it's hard for me to say whether one is, more harmful than another. There were other people suggested that they were, and that was the reason for the ban.
I just make sure that I understand the effect of your evidence between paragraphs 163 and 166 of your witness statement. Can you go to 163, which is on the screen? And when you refer there to Burswood's EGM business, are you referring there to the commercial aspects of the EGM business and for example, the turnover and improvement of turnover and such like?
Yes, I imagine I was in an overall sense, yes.
And when we go to 164 then, and we're looking at the internal audit reports and the internal audit ratings of satisfactory, minor risk, moderate, medium risk, is that just, on your understanding, going to the commercial risks or also matters the subject of the responsible service of gaming?
I would say the latter. So the commercial and the concerns around risks of harm.
But again, you didn't know precisely what kinds of audits were being conducted in relation to EGMs and what controls or risks were being tested.
So as I said in 165, I understood that the risks of public gambling associated specifically with EGMs were addressed by the Responsible Service of Gaming framework, as discussed elsewhere, and indeed which had the input of that committee at CRL level.
If I can take you to this document, please, CRW.702.001.6952. This is a business plan for the year ending 30 June 2013 that was provided to the board. And if we go to 6954, please. And we drop down to the last dot point of key strategies. Introduce ticket in, ticket out and cashless technology to the gaming machines environment. And maximise the use of improved functionality, bonus, extra play of the IGT Advantage system to enhance gaming machine growth and customer experience. See that?
Yes.
And all of that was about increasing turnover, wasn't it, of the EGM machine business?
Yes.
Do you consider that there was sufficient attention given in the business plan to harm minimisation in the context of growing the business, the EGM business?
I would need to refresh my memory, given that this is 7 or 8 years ago, as to whether that were the case. I would say that if it isn't specifically covered there, the harm minimisation would have been, again, the purview of other parts of the business, in essentially alongside the desire to get more turnover and provide a better experience to the customer, as well as not being irresponsible in that.
Well, was that a focus, that harm minimisation in relation to EGMs, was that a focus of the Burswood Limited board in terms of its monitoring and oversight at all, or was that left to other parts of the business?
So, as you can see in the minutes, there were various reports provided to the Burswood Limited board about responsible service of gambling over the fairly long period.
Let's go to page 6960, please.
Whilst that's coming up, so this is described as Burswood Limited's business plan, and it's all about running the casino. So why do you say that that wasn't Burswood Limited's business?
Well, it's an all-encompassing term, Commissioner. As I said...
What's an all-encompassing term?
Sorry?
What is an all-encompassing term?
Well, so I come back to the point that this company, Burswood Limited, to which we're referring all the time, has one shareholder and one asset and no staff. So essentially what's happened over time, it's Burswood, or Crown Perth, has become an all-encompassing term for the business of the Perth casino. What I'm saying is the whole time is that this particular company sat in a chain of other companies where the ultimate responsibility for all of those activities resided, i.e. at the board level of CRL and its various subcommittees that were established. So this is essentially a one-way set of information where we're receiving information. We can't control things. We can approve or we can agree or encourage adoption of things, but we don't have a whole lot of people working for us that we would in normal circumstances, a board of directors, through the CEO, be able to direct.
Well, why is it called Burswood Limited Business Plan?
Good question.
Thank you, Ms. Cahill.
Thank you, Commissioner. Now, at page 6960, there's additional opportunities identified in this business plan. First two dot points. Spinning reel machines for the exclusive use of international interstate patrons, and reduction in machine spin rate cycle times. Did you understand that to be a reference to making the machines like poker machines for interstate and overseas players?
I don't know what I was thinking at that time. Obviously, if if spinning reel machines or pokies were banned for use of the normal local player, this must have been seen as an opportunity. I'm not sure that it ever went anywhere. So that's all I can say about that.
But when reading this, whether it went anywhere or not, did you have any concerns that Burswood management, Perth casino management, were not sufficiently focused on and emphasising deference to the poker machine ban and harm minimisation associated with EGMs?
No.
At 6963, under the heading Gaming Machines, you see there at about 0.5, this is a report and then a plan for the year going forward. And if you just read those dot points, rebranding campaign to re-attract an uncarded demographic, new loyalty program, additional product for peak periods, cashless technology, jackpot offerings and so forth. You see the second last dot point, more aggressive free credits and mail campaigns?
Yes.
Did you get the sense that what management was proposing to you was an aggressive marketing of EGMs at the expense of harm minimisation strategies?
I think this shows an emphasis on trying to generate revenue. It doesn't tell the other story about harm minimisation. To that extent, it's probably the wrong messaging for sure.
Are you aware of amendments in 2019 to the WA appendix to the Gaming Machine National Standards?
Not specifically.
That these were instigated by Crown?
Again, not specifically. I'd need to be reminded.
Let's go to GWC. This is a document not for publication, gwc.0002.0016.0268 at page 0077. So here's some Crown Perth letterhead, 7 March 2019, letter to Mr. Ord. Do you recall seeing this letter before today?
Beg your pardon, sorry?
Do you recall seeing this letter before today?
No.
And essentially there's proposals for the amendment to the standard for the reasons given in the last paragraph.
Yes.
Commercial disadvantage to Crown Perth against other casino operators interstate and internationally. If we go over the page to 0078, proposal to reduce the speed of play from 5 seconds to 3 seconds. See that?
Yes.
Do you recall approving that proposal be put to GWC at the time?
I recall being told that it was something to be discussed. I don't recall approving it per se.
Is it something that caused you any concern?
No.
Did you consider it was something that could increase the risk of harm to casino patrons playing electronic gaming machines?
Not specifically.
See the next one, return to player, seeking to have the return to player reduced to bring it in line with other states,
Yes.
so that effectively the patron loses more money. You understood that much?
I guess that was the intention to generate more revenue for the casino and therefore for its shareholders.
And then at numbered paragraph 3, under the heading Cost of EGM Development, did you understand that what Perth Casino Management were really wanting to seek to do here was to change some of the design features of the EGMs at the Perth Casino to make them more like poker machines in order to save on the cost of game development?
Certainly, my understanding was the fact that EGMs were different from machines in every other venue around the country, pubs and clubs and other casinos, that this was an ongoing issue in terms of the cost of the machines and getting people to actually design them. So it doesn't surprise me that there was an attempt to standardise it such that there'd be more overlap, if you like, between machines that the manufacturers were making and what the casino was required to have in play.
Did you have any concerns in your mind at the time, or consider that changing some of the design features of the EGMs could increase the risk of harm to patrons at Perth Casino using those machines?
I wasn't specifically concerned about that, as there were systems and programs in place to minimise harm and manage that issue.
Do you agree with the benefit of hindsight that you were not, as a director of Burswood Limited, holding management sufficiently to account in respect of their management and conduct of the EGM business in the context of appropriate harm minimisation measures?
No.
Different topic now, Mr. Poynton. During your tenure as a director of Burswood Limited, did you acquaint yourself with the contents of the Burswood Limited constitution?
I can't specifically recall at the time I became aware or studied it, but I have studied it.
We go to pub.0026.0002.0001. And at page 0010, if we can pull out clause 3.12 with its heading, please. You familiar with this
Yes, I am.
clause of the Constitution?
Yes.
Did you understand it to be a clause of the Constitution inserted by reason of a requirement in the state agreement?
Yes.
And for the purposes of this clause, what do you say is the business of Burswood Limited?
Object. That's really a question of proper construction of the agreement. It's not a question on which he can express an opinion.
Well, I think if he's asked whether he ever turned his mind to that question, to that distinction.
Asking him what he says is the business for the purposes of this clause. So if you answer that question, please.
Can you ask it again?
You see there in the second line, when it says the head office of the company must always be located in WA. For this purpose, head office means the place of business of the company. That's Burswood Limited. For the purposes of this clause, what do you say is the business of Burswood Limited?
The business.
First of all, have you ever turned your mind to that issue?
I think the legal structure determines what the business is. In the strictest and narrowest sense, it's managing the asset that it has, which is one or more units in the Burswood Property Trust. It has subsidiaries that have a licence, that have employees, have executives. The responsibility of Burswood Limited is to its one shareholder, which is ultimately CRL. So it's a bit of a misnomer, unfortunately. I'm not sure when this was originally put up, that was it at a time when Burswood Limited was a listed ASX company, or subsequently?
So just coming back to this clause, did you, just to answer Commissioner Owen's question, have you ever turned your mind to this clause in terms of the structure of the Burswood Limited business?
Yes, as I said, with the aforementioned caveat. So in 2005 or 4, whenever it was that PBL and then ultimately CPH took control of this company, it was pretty clear immediately that the overall control, given what we've talked about companies in the chain, had moved, and in that case to Sydney. Now, I don't recall at any stage anyone in government or the regulator raising concerns about that.
Well, the central management of Burswood Limited, do you say Burswood Limited has any management?
No, it doesn't.
And the control of Burswood Limited, where do you say that's exercised?
I say the control of Burswood Limited is firmly in the people that appoint its directors and who own the shares in that company.
In any event, you've never, either in your capacity as a board member of CRL or in your capacity as a board member of Burswood Limited, raised this issue of clause 3.12 and said to anyone, well, I think we can't have a centralised casino operation function outside of Western Australia insofar as it concerns Perth Casino.
As I said, I think that's a matter for the government and the board of CRL to determine whether that's satisfactory from their point of view. I'm not sure that there was ever a requirement to have independent directors of Burswood Limited in the same way that I think in Melbourne there is a very specific requirement about the company controlling that asset there. Certainly I'm aware of this requirement, and it went away as something that government seemed to be concerned about 15 or 16 years ago, because otherwise they would have insisted that the overall business in the whole context of these companies sitting in the chain should have been administered out of Western Australia.
Just on a related topic, but a different topic, paragraph 40, that's 40 of the witness statement, page 0009, refers to the Crown Melbourne and the Victorian regulator. And in response to a request from this commission that you give evidence on a particular topic, you say you don't recall reviewing clauses 22.1R and RA of that agreement. During your tenure as a director of Crown Resorts Limited, did you read that Melbourne Casino Agreement at all?
I can't recall reading it during that tenure, but I've read it subsequently.
And have you read and recall clause 22.1 RA3?
I'd need to be reminded of it, but it has to do with the administration of the Crown facility.
Well, it's a promise to ensure that Crown Resorts Limited maintains the Melbourne Casino as the flagship casino of Crown Resorts gaming business in Australia. You recall that?
Yes.
And while you were on the board of CRL, did CRL maintain Melbourne Casino as the flagship casino of CRL's gaming business in Australia?
Yes, as far as I recall.
How did it do that?
Well, it had an emerging operation in Sydney, which hasn't ever opened, and it had an operation in Perth, which was much smaller. And so by definition, flagship, if that's the term you want to use, was in Melbourne.
So does that mean, therefore, that the Perth casino could never be developed to become a larger casino attracting more business than Melbourne?
Well, almost by definition, it wouldn't matter really what one did. Melbourne is a much bigger city, it's got a higher profile, and it's hard to imagine, and I haven't ever done or seen the numbers, but it's hard to imagine that investing another $1 billion is going to make it more of a flagship in a revenue sense or a profit sense than Melbourne.
So flagship is just really a size thing, is it, in your mind?
Well, it's like any adjective, what does it actually mean?
What does it mean to you?
I take it to mean the biggest, the most prestigious, the highest revenue, the highest profile.
So how is it made more prestigious than Perth?
Only by virtue of size and presence in a major city.
Once you joined the CRL board and you had responsibilities in relation to Crown Melbourne as well as Crown Perth, did you perceive any conflict between your role as chair of Burswood Limited or as a member of the Burswood Limited board and your role as a director of CRL, having regard to that clause I've just referred you to?
Not specifically, no, because of the size differences which were evident. And indeed that, the meetings of CRL were mostly held in Melbourne. The management, as I understood it, was mostly located in Melbourne. and it was being run out of Melbourne.
Right, now paragraph 33 of your witness statement, I'm changing topics here, you referred to a consultancy agreement that you made on the 7th of May 2018, which is JHP.001.001.0001. And this coincided with your nomination to the board of CRL. You recall
Yes.
that?
Yes, I do.
Now, that consultancy agreement's being displayed on the screen. You say at paragraph 34 that the legal purpose of the consultancy agreement was to ensure that you were not considered an independent director of Crown. But you didn't require a consultancy agreement to be identified as a non-independent director, did you?
It was to put the matter beyond doubt.
Well, it could have easily had the matter put beyond doubt by you being noted in the records of the company as a nominee director. Would you agree?
The idea of entering into the consultancy agreement was Mr. Packer's. That's what he wanted to do, and I agreed.
You disclosed the fact of the consultancy agreement to Mary Manos, the CRL company secretary at the time, didn't you?
Yes.
Did you also provide her with a copy of the agreement?
I can't recall.
Going to the document itself, you'll see on that front page that it is an agreement only between CPH Pty Ltd and this is your private company, Mulloway Proprietary
Yes.
Limited, is it?
And
you as the nominated representative. Is there a reason why CRL or a CRL entity was not made a party to this agreement?
Because it doesn't involve them. I'm not sure why they would be a party.
You say it doesn't involve them.
Well, not specifically. My relationship with Consolidated Press doesn't. It's declared that there is an association, and therefore I don't think CRL needs to be a party to it.
Right, now we'll just have a look at where we are. You'll see that the company here is defined as CPH Pty Ltd, Consolidated Press Holdings. You see that?
Yes.
And then if we go down to the definitions on page 0002, you'll see at point 7.8 a definition of group. So group means Consolidated Press Holdings Pty Ltd, Crown Resorts Limited and each of their related bodies corporate.
Right.
Yeah. And then services are defined just a little distance under that.
Yes.
And the services means you acting as a non-executive director of CRL to represent CPH Pty Ltd.
Yes.
And then over the page at B, providing, just blow that up, such other business services as requested by CPH Pty Ltd from time to time, and you say no other services of that description were provided.
I say that.
Right. And so the only services provided under this agreement were acting as a nominee director on the CRL board.
Indeed.
So we go to clause 4.1 at 0004. And these are the duties and responsibilities of the consultant. That's Mulloway and therefore you. You would agree that?
Yes.
Yeah. And if we drop down to little g, provide full and prompt information to CPH Proprietary Limited regarding the provision of the services, including any material issue or information within the consultant's or nominated representative's knowledge affecting the company. Did you consider that clause obliged you to disclose material confidential to CRL and its board to CPH Proprietary Limited?
No.
Did you make any such disclosures?
None.
Either, all right, and did you disclose the existence of this clause to CRL or Burswood Limited?
No. Can I just confirm that the word company refers to CRL, not to CPH?
Just go back up to page 001, please. company refers to CPH Proprietary
Correct.
Limited,
not
not
CRL.
CRL. Not CRL.
So can we just go through that question again for the record? So there is no suggestion that I was to provide confidential information regarding CRL to CPH.
Can we go to page 0005, please? And do you see the consultancy fee at clause 5.1?
Yes,
Consultant would be paid a fee of $50,000 per annum by CPH Proprietary Limited for being a nominee.
yes,
You were also being paid by CRL as a board member, weren't you?
I was.
How much?
I think directors' fees are something like $120,000 or $130,000, something like that.
And you were also being paid for your directorship of Burswood Limited at the same time?
Correct.
How much?
That was $80,000 a year.
Right.
And it's important to note that the fee didn't change between 2004 and 2019.
Did you disclose the fact of this payment pursuant to this agreement to CRL?
I recall talking to Mary Manos about it.
Did you disclose the fact of this payment to the board of Burswood Limited?
Yes, as far as I recall, given that John Alexander was chairman of the company at the time and was obviously working as executive chairman of Crown and also close to James Packer, he would be aware of this.
So if we go to page 0007, please. Clause 7.3. Just zoom in on that, thank you. A consultant and nominated representative, that's you and your company. Covenant, that's promise, both during and after termination of this agreement, that the two of you will little c, upon demand by CPH Proprietary Limited, deliver to CPH Proprietary Limited confidential information in the possession, power or control of the consultant or the nominated representative. If we go back up to page 0001 and look at the definition of confidential information. Sorry, I'll go over to page 2. You'll see there that confidential information includes confidential information of the CRL group, the Crown group.
Yes.
Well, why did you agree to deliver confidential information of the CRL group on demand to CPH Proprietary Limited?
Does it say on demand?
Go back to 7.3C at 0007.
On demand.
Why did you agree to that term?
I'm not sure in hindsight. What I would say is it never happened.
Did you consider that the existence of this clause created a potential conflict between the duties of confidentiality you owed in respect of CRL board discussions, Burswood Limited board discussions,
Yes.
and your obligations under this clause?
Yes.
Did you disclose this clause to the contents of this clause to Crown Resorts Limited?
I can't recall, but I'm pretty sure that I spoke to Ms Manos about it.
What about Burswood Limited board? Did you make any disclosure to them about this clause?
I can't recall whether anything specific was mentioned to the Burswood Limited board about it, but I probably would have spoken to John Alexander about it.
Now, you said that you didn't make any disclosure of
As determined by Commissioner Bergen.
confidential information. So I'll just go back a step. You say you didn't make any disclosure of confidential information
No.
to Mr Packer or CPH Proprietary Limited pursuant to this agreement.
Correct.
Did Mr Packer make any demand? Did he issue any demand for confidential information?
No, not at any stage. And as I said, for the record, the Bergen inquiry looked at every piece of correspondence, text, email, whatever other, to determine what information had flowed from CRL directors to CPH and Mr Packer. And in my case, there was none.
Did you tell the Bergen inquiry about the consultancy agreement?
They knew about it. They already had the records of it.
Right. Did you provide that to them?
It was part of discovery.
Did you provide a
I
copy?
can't recall.
I'll just finish the question. Did you provide a copy of the consultancy agreement to the Bergen inquiry?
I can't recall where it came from, but I wouldn't be surprised if I did. They either got it from me or they got it from CPH. They were aware of it and they have a copy of it.
Now, you terminated this consultancy agreement on the 10th of February 2021, didn't you?
Correct.
And did you comply with clause 8.3 on termination? I'll show you that clause. It's at 0010.
I provided and returned nothing to CPH because I didn't have anything to provide.
Why did you agree to this term? Which,
I didn't see it as onerous.
well, it requires you on termination of the agreement to return to CPH Proprietary Limited all tangible property of the Crown Group.
It was never called upon and I didn't expect it to be called upon.
So why did you agree to it in the first place?
I was presented with this agreement and I signed it. I didn't regard that obligation as being something that would cause me to compromise my position on the board of CRL.
Now, finally, just to clarify your evidence at paragraph 54 of your witness statement, page 0013, I'll just give you a moment to quickly look at that paragraph. I have the wrong page number, so 54, 0012, I beg your pardon. Just have a look at the second sentence and the third sentence, and then I'll ask you a question.
Yes.
You didn't regard yourself as having the status of an independent director immediately upon termination of the consultancy agreement, did you?
Not at all.
But you thought that you could achieve that independent status 3 years after the termination of that
Correct.
agreement. Thank you. I have no further questions.
Thank
Commissioners?
you, Ms. Cowd. Now, does anyone apply for leave to cross-examine?
Not other than in the general way, Mr. Commissioner.
Okay, how long do you think you'll be?
I have conferred with my learned friends, and there are three of us, including Mr. Ward, who would seek to, Mr. Ward would be re-examining, but two others would seek to cross-examine, and we think three of us in total will be between 45 and 50 minutes.
Mr. Poynton, are you prepared to sit a little longer today?
Sure.
I hope we can.
By all means, Commissioner.
And if you feel that you would like a break at any stage, let me know.
No, I'm happy. If it means I don't have to come back, I'm happy.
Understood.
Thank you.
Can I just ask you to speak up?
Yes, of course.
Having trouble hearing you.
I will speak up. Mr. Poynton, in your witness statement, you mentioned Crown Towers as a VIP asset at Crown Perth.
Yes.
That development occurred during your tenure on the board of Burswood Limited.
Indeed.
To assist the commissioners in understanding the nature of that development, would you be able to comment upon its cost and the amenity it offers?
Indeed. So the cost of the project was $645 million, and it was part of an investment of around $1.1 billion that occurred during my tenure on the board of Burswood Limited. It was designed to really cement that precinct as a premier tourist operation, both for interstate, international and local patrons. and as such was, you know, a very exciting development and has subsequently proved to be iconic. Unfortunately for the company, the investment decision was taken coming straight out of the mining boom, and indeed the premise on which it was built was that it was going to make a certain amount of money. When it opened in late 2016, it was a very quiet time in the West Australian economy, and it took some time for it to climb back up. In fact, I think ironically, coming out of COVID was the first time it made the kind of budget numbers that it was supposed to do. So it was a brave investment and not a successful one initially, but obviously we now see its impact.
Thank you. You also mentioned in your witness statement at paragraph 161A, the Crown Ability Program.
Indeed.
That's a program to create job opportunities for persons with disabilities. Are you able to assist the Commission in understanding the nature of that program and the type of benefits that flow from it?
Yes. I guess what I would say is that not just in that program but others that are mentioned, Crown attempts to be a good corporate citizen, and it has obviously instigated programs nationally like Crown Ability, the Indigenous Employment Program, and the ones that are mentioned, Gender Equity Subcommittee, etc., and the Crown Foundation. These are designed to cement its position in the community as a good corporate citizen, and indeed, I think, you know, has done very good work in helping these marginalised people.
And what kind of attention was given to these programs at the level of the Crown Resorts Limited Board?
There were regular updates on these social programs and these employment programs, and the board was directionally, for obvious reasons, very supportive.
And what type of expenditure was given to community programs and charitable programs, to your knowledge, during in any given year?
I can't remember the numbers, but you know, not so much donations. Say the Crown Foundation, etc., might be, you know, $3 or $4 million, something like that. But these programs did actually cost quite a lot of money. I don't know the specific numbers, but they were significant investments the company made.
Thank you. During the course of your cross-examination, there was a reference to the evidence that you gave in the Bergen inquiry before the luncheon adjournment. Do you recall that?
The what, sorry?
The evidence that you gave in the Bergen inquiry, there was a reference to that by counsel assisting before lunch? Yes. And you were asked a question in respect of that about the AML program.
Yes.
You weren't taken to the relevant document. This is a document which is not to be put on public screens, but if we go, please, to CRL, and I have a hard copy also here that might assist, but CRL.695.001.004. Is that displaying on anyone's screen?
No, not yet. Not mine.
0004. We might have to work from hard copies, Commissioner. So I think we have a number which for the witness and the commissioners.
The so-called paperless courtroom is still a dream.
It is.
It's on the screen.
It
It
is.
is.
All right, it's up now.
Yes. Have it.
You, on your saying that, Mr. Commissioner, it showed up.
Magic.
So, if we go, please, within that document to page 18, 0018. You see that is a page that marks an appendix. Mr. Pointer, do you have that?
So is that,
The page numbers are on the,
I have page 18.
yes. It's on the top right-hand corner. It's very small writing.
Should have
0021.
It's on his screen.
It's on the screen, Mr. Poynton.
0018.
So in the appendix, there then appears the statement to which you were taken in the Bergen inquiry and to which you were taken today, and that's within capability, which says the AML team has been under-resourced and lacking in qualified AML executives. Do you see that?
Yes.
So that line was within an appendix reporting on the ILGA observations to date. If we then go, please, to page 0006.
Yes.
You'll see there that then identifies the improvements implemented, and the first line records that Crown has been progressively implementing a range of improvements in its compliance processes since 2017.
Yes.
Does that refresh your memory in relation to...
Absolutely, yes, it does.
And then if you look under the heading AML, there's a reference under the third bullet to an increase in the resources of the AML team. Do you see that, Mr.
Yes.
Poynton? And that, again, does that assist your memory at all?
It does, yes.
Thank you. You were appointed a non-executive director of Crown Resorts in 2018,
Correct, late 18.
and that was pursuant to the consultancy agreement that Council Assisting took you to,
Yes,
and you were filling a vacancy left by Mr. Packer's resignation.
correct.
Mr. Packer offered you the position of non-executive director of Burswood in 2004 after you assisted PBL in the acquisition of Burswood.
Correct.
In your statement, you make some observations about the Bergen report, and at 52 you record that the Bergen report did not make any adverse findings against you.
Correct.
You then explain your thinking about the work that needed to be done after the Bergen report, and that's at paragraph 53, and we can go to that. Paragraph 53 of your witness statement. You see there that you record that you had formed the view that the prospects of recovering the license depended upon the reduction of the CPA directors on the Crown board to zero, in effect.
Indeed.
And you recognised that the presence of CPH directors and CPH connections was a problem for Crown in light of the Bergen findings.
Indeed, I did.
You then recorded your witness statements various observations made by Mr. Crawford, who appeared to be saying what you had already worked out, in that CPH directors were a problem insofar as Crown Resorts was concerned.
So there's quite a lot to say about this, so if the Commission can indulge me. Taking you back to early 19, I think it was, when Mr. Packer attempted to negotiate a sale of some of his shares with Wynn, and that was leaked and that transaction didn't go forward. Subsequent to that, he then agreed to sell up to 20% of his holding, 20% of holding in the company, to Mr. Lawrence Ho, Melco. That actually triggered, amongst other things that triggered it, the Bergen inquiry. What we had, I guess, there is a pattern of Mr. Packer trying to reduce his influence, trying to balance up his portfolio and have less involvement in the company. He was subsequently thwarted, dare I say it, by the inquiry and then the second part of the transaction to Mr. Ho was cancelled, and then Mr. Ho sold out to Blackstone. My point here was that it was pretty clear that there was a problem with Mr. Packer's involvement. However, he was actually trying to address that. Part of the addressing was to actually reduce CPH directors. But Ms. Bergen had no issue with me staying on the board, notwithstanding my previous involvement with Mr. Packer. And indeed, I took the view that given what Mr. Packer had been trying to do, it was almost inevitable that over time his influence may well go to zero, but certainly to a point below which any association I might have had with him was no longer relevant.
All right. You say in your witness statement in paragraph 59 that you instructed your lawyer to write to Crown Resorts indicating your preparedness to resign, and you say there that Mr. Lestrange advised Mr. Zweier that I was willing to tender my resignation provided Mr. Crawford publicly confirmed that the decision I should resign is based only on a perception of my past association with CPH and Mr. Packer by virtue of the consultancy agreement. You see that?
Yes.
And you are thus prepared to resign on practical grounds because you recognise that your relationship with CPH made your position untenable in light of the Bergen findings.
What I also said is that the situation was that I was placed in a position where both the chair of the company and Mr. Crawford were suggesting that my staying on the board would mean that the licence would not be granted. And in one stage I was given 2 hours notice to quit the board, and that this is all in the public record. So my point subsequently has been I got off the board because I thought at the time it was in the best interest of the company if the company was not going to be given a licence by ILGA and Mr. Crawford. Some 6 months later, the company still doesn't have a licence. Therefore, I would respectfully put that me being on the board had nothing to do with that.
What you were doing when Mr. Lestrange was communicating with Mr. Zweier was making it clear that you wanted the basis of your resignation to be absolutely clear.
Correct.
And Mr. Crawford then provided you with the confirmation that you wanted. Correct?
No, I'm sorry, he didn't. He didn't actually adopt the words we wanted him to, and there were subsequent further threats made by both Mr. Crawford and Ms. Coonan that led me to have an untenable position.
So, but you say in your own evidence at paragraph 62, despite this confirmation from Mr. Crawford, I remain concerned to protect my reputation. So your evidence is that the confirmation that you had sought was obtained.
What wasn't in the words that satisfied me.
Your evidence in paragraph 62 says, despite this confirmation. Do you see that, Mr.
Excuse
Poynton?
me, may I just object to that question on the basis that it's a false premise. What's being put is that the confirmation referred to in paragraph 62 is the confirmation that was sought by Mr. Lestrange in paragraph 59.
Sorry.
What is being put is that the confirmation referred to in paragraph 62 is the confirmation sought by Mr. Lestrange in the correspondence referred to in paragraph 59, but that's not. What it is
I understand the point. What came from Mr. Crawford is in paragraph 61.
Well, it starts in paragraph 60. It's from Ms. Coonan's letter. It's not what was Mr. Lestrange sought.
Put it on that basis, Mr. Darwin.
On that basis, that there might have been some differences between you about the language, you still say in paragraph 62, despite this confirmation from Mr. Crawford, I remain concerned to protect my reputation, and you mentioned that there were no findings to suggest that you were not fit and proper. So is it fair to say that at that stage, despite the confirmation to adopt your language in paragraph 62, you were not prepared to resign?
It's a semantic point again, but if you have a look at the wording from Mr. Crawford, it says words to the effect that we're not asking Mr. Poynton to leave because they're, of adverse findings. I'd need to see the words, but he didn't say in a positive affirmation sense that there were no adverse findings. What he said...
I'm sorry to interrupt you, Mr. Poynton.
No, you
Please
go.
go ahead. No, you go ahead.
Well, I'm just saying that there was a campaign conducted in the media against me by Mr. Crawford that was based, in my view, on a false premise. There was nothing in probity in New South Wales to say that someone couldn't be on the board of a casino company merely because of a previous association with Mr. Packer, and that was certainly what Ms. Bergen suggested, or indeed that they were not independent. And so what I was trying to do, if I had to go because I was getting this pressure, was actually at least get the Commissioner to say, in a positive sense, that we recognise Bergen, we recognise there were no adverse findings. The wording subsequently that came back did not satisfy me, but I was still placed in a position where I had no choice other than to resign.
The wording is actually in paragraph 61 of your witness statement, where Mr. Crawford writes to you and says that it's not based upon any adverse findings.
Yeah, and if you read that, not based on adverse findings, in other words, the inference in the English language is that there were adverse findings, but you being asked to leave isn't causing that to be the reason. Is not based on adverse findings. In other words, well, were there adverse findings? Sounds like there were, but that's not the reason we're asking him to go. It's not positive affirmation.
I understand, Mr. Poynton, but you asked for a certain confirmation, you obtained it, you then decided that that was insufficient, or you wanted to remain on the board. Is that, would it be a fair...
I object again. Again, the question put, you obtained the affirmation you wanted. That is not what is said in this statement. What was sought is set out in paragraph 59. That is different to what was given in paragraph 62.
We may be reaching somewhere of
Yes, I
an
understand.
impasse on that, Mr.
Yes, thank
Barnham.
you. You accept, don't you, Mr. Poynton, that you could not be considered an independent director of the board of CRL in view of your consultancy agreement?
Correct, as I hadn't been up to that point.
You, to your knowledge, CVH did not want to have any further involvement on the Crown board through nominee directors following the Bergen report.
Correct.
And if that is so, the only way that you could remain on the board would have been as an independent director.
Not at all. Just because Mr. Packer's representatives on the board, the other two, resigned, didn't mean that I had to resign that position. I could have stayed on as a non-independent director merely because of the historic association. There's nothing in the Constitution or anything that would suggest that. And I would make the additional point that I had specific expertise that I think, given the $2 billion reduction in the valuation of the company since I left, might have assisted.
You accepted, and I think you confirmed with counsel assisting, that you would not be able to be considered an independent director until 3 years after the date of your resignation, correct?
Well, up to 3 years. There seemed to be some subjectivity around that, given it's an ASX guideline. I don't think it's actually a legal requirement.
You say in paragraph 54 that you considered it important that you were considered an independent non-executive director.
Yes.
But you could not be so considered until 3 years after 10 February 2021, correct?
What I'm saying is that there was a contemplation that that's a place I was trying to get to. There was no legal or other Bergen-related, ILGA-related obligation for me to leave, merely because I was not independent. So that was an aspiration. And unfortunately, given that I wasn't there, subsequently, it's pretty clear what could have happened in terms of willing buyers, willing sellers, a transaction. It wasn't as if I was trying to cling on to some role as a director going forward. I wanted to be part of a situation which would have led to Mr Packer achieving what he was trying to do previously, which was to reduce his influence. Therefore, any previous influence I might have had or in connection with him would have evaporated.
Thank you. No further questions.
Who else is seeking leave?
If I could just seek leave for one or two questions, hopefully, Commissioners.
Mr Evans?
Mr Poynton, Council Assisting has taken you to a...
Sorry, do you know who Mr Evans is representing?
No.
I appear for the Gaming and Wagering Commission, Mr Poynton.
Sorry, I
I
can't...
appear for the Gaming and Wagering Commission.
Oh, right.
Council Assisting has taken you today over quite a number of transactions and documents over the course of the 16 or so years you were a director of Burswood Limited and later Crown Resorts Limited. Mm. But I just wonder if I could concentrate on a couple of matters to understand the position immediately prior to your retirement as a director of those companies.
Yes.
And perhaps I could start with the transaction that you referred to in answer to a question from a learned friend, Mr Dharmanandra, a minute ago, and that's the capital investment that was made in the capital investment program in Burswood commencing in 2012, 2013, which was the Crown Towers program. You said that was about $1 billion. Do I take it that the capital investment decision that was made then was a Crown Resorts Limited decision?
It was a Crown Resorts, absolutely a Crown Resorts decision, but obviously there was some input by the board of Burswood Limited as it related to the two independent directors about the economic and political environment of Western Australia ahead of that, which was, I guess, feedback given up into CRL.
Yes, but the decision on capital allocation was made by Crown Resorts.
Absolutely.
And would it be fair to say that up to the time of your retirement, all significant capital expenditure decisions were made by Crown Resorts Limited?
Yeah, because it was the head office and it owned all the assets.
And I think you've already indicated in your evidence in chief that the international business was managed at a Crown Resorts Limited level?
At a group level, yes.
Yes, principally by Mr Felstead, who, although resident in for much of the period, resident in Western Australia, but in fact operating principally out of Victoria.
He was, Mr Felstead, as I understand it, and you need to check with him, was hardly ever here once he took on a national role.
And I think you also indicated that at points in time, the risk management framework was driven out of...
Risk management started at CRL level,
yes,
and was devolved as it related to the subsidiaries for, information.
And I took it from Mr Ward's statement on your behalf yesterday, also on Monday, that if anything, that is a position which has increased over the last few years, and most recently in 2020 under the improvement program that Crown Resorts has suggested it's undertaking.
The more sharing of information, you mean?
Yeah. The centralisation of functions.
Oh, sorry. Yes, I think, and it's in some minutes, I think back in, might be 20 after or during the Bergen inquiry, there was quite a discussion about collapsing the subsidiaries into group, into head, CRL. And I think there was quite strong support for that, given some of the shortcomings that have been identified. And indeed, the only issue I had was this this ambassadorial role that I thought still had importance, but there'd been some, concerns around this sort of devolved structure, letting things, if you like, fall through the cracks. So hence the idea to take it up into group. And of course, now as we've seen with Mr Finkelstein in Victoria, if each state adopts a requirement for there to be absolute control at the state level, then almost inevitably the company must be split up because it becomes mutually exclusive.
And that ambassadorial role is one which could be performed in a number of ways. It doesn't actually require a director.
It definitely could be, and I think was contemplated in, if you like, an advisory board role where it was very clear there were no fiduciary duties whatsoever.
I was going to ask you that. Is it the case that, to a very significant degree, the Burswood Limited board functioned as a Western Australian advisory board to Crown Resorts?
That's always been my contention.
Yes.
It was the intention of Mr Packer at the outset and continued on. And when you look at the evidence, that's the way it was run and regarded. And I think that this commission has work to do to determine what it looks like if in fact each state regulator insists on what Mr Finkelstein sounds like he's going to insist upon, because almost inevitably there can be no national casino companies.
So to understand the position as at the end of your tenure in the beginning of 2021, capital allocation decisions were made for Western Australia at Crown Resorts.
Yes.
The responsible gaming framework originated at Crown Resorts.
So
The risk management framework
if
commenced...
you
Sorry,
look-
Mr Point of View, this is actually a
Sorry.
yes/no question. Risk management originated at Crown Resorts? Yes.
So what I would say is all you need to do is look at the subcommittees, or if you like, the board committees of CRL, to determine what the board of CRL believes is in its purview.
And those were not reflected at Burswood Limited level, were they?
No.
At any time?
No.
Not today?
Well, not with...
Not while you were a director?
Not, if you think about ASX guidelines requiring independent directors to make up the majority of a board committee, clearly there were independent directors at CRL, complying with that guideline, and indeed devolving, if you like, by information, some of those decisions to, well, not devolving, but informing the Board of Burswood Limited and the other subsidiaries about matters, to do with, risk management and AML, etc.
But informing for them to adopt?
Well, informing... See, at the end of the day, Burswood Limited had no real power. At the end, if in fact...
Mr Point, we understand your point in relation to that. My
Yeah.
question is, as at January 2021, central management and control of Burswood's activities in Western Australia rested in Crown Resorts?
Absolutely.
Thank you. I believe there's one question which is possibly more general relevance to the state than to me, which my learned friend Ms Seaward might properly put.
Ms Seaward represents the department as opposed to the Gaming and Wagering Commission.
Thank you.
Mr Poynton, following on from those questions from Mr Evans, you were asked questions as well by Ms Cahill about the constitution of Burswood Limited, and in particular clause 3.12, which is the head office of the company must always be located in Western Australia. You've agreed that the central management and control of the Crown activities in Western Australia were run interstate. You said that was a matter for the government. Did you, as a director of Burswood Limited, ever ask if anyone had informed the state or anybody in the department that central management and control was being run out of Western Australia?
Outside of...
Outside of Western Australia?
No, because I have to think that it was self-evident. Various people, including Mr Packer from time to time, came to Perth. As I understand it, had the occasional meeting with senior figures, and I would have thought that it would have been self-evident that, in fact, at least initially in Sydney and then later in Melbourne, that the business as a listed public company was being run out of another state.
Did you ever ask if anyone had discussed, therefore, whether this clause 3.12 was something that the state thought was being complied with?
No, because, as I said, and maybe it was an incorrect assumption, but it wasn't as if this was not a high-profile company. It was, I would have thought, given all the requirement for the company to provide information to the ASX and its shareholders, evident where it was being managed and indeed where the board of directors resided.
These are assumptions you've made, is that
They're
correct?
assumptions, yes, and
You've
indeed...
seen no
where the-
paperwork
No,
that this
not that
matter
I'm-
was ever raised with the
not that
state
I'm
or
aware,
discussed
no.
with the state?
I didn't, but as I said, I wasn't the chair of the company when the decision was taken. So whether that chair did, I'm not sure.
You didn't ask if he had done that?
Not specifically that I recall, but this is 16 years ago.
Thank you. No further questions.
Thank you. Is there anyone else? Commissioner Jenkins?
Yes, thank you. Can I just ask you, Mr Poynton, I understand what your position is. You've made it very clear, I think, about what you understood that Burswood Limited's role was, but I just want to ask you a few questions about that. You said that it had no employees, but it wasn't the case that it couldn't employ people, was it?
No, it wasn't the case it couldn't at all, just never did.
It made its own decision not to employ
Well, by
people
default, I
to help
assume.
it discharge its functions.
Yes, yes.
And you said that it had no power, but that's not true either, is it? Just chose not to exercise the power in terms of governance. Or it was directed not to do so by CRL.
It was never directed not to direct. It was evident where it sat in the chain as to what its powers were and the limits to those powers.
Well, Burswood Nominees Limited was its wholly owned subsidiary.
Yes,
Burswood Resort Management Limited was its wholly owned
yes.
subsidiary. So, absent any direction or implied direction from a parent company, it had power, did it not, to direct its wholly owned subsidiaries, just like CRL, you say, had power to direct Burswood Limited.
It delegated whatever powers it had, as far as I can tell, to those subsidiaries. The practical import is...
Sorry, just stop there. I think we're getting a bit beyond ourselves, but I'd like to pick up on that. My question was, it's not a case that Burswood Limited did not have power over its subsidiaries, is it?
It's probably more in the exercise of the power. So in a strict legal sense, again, it had its own directors, we had our directors. So presumably, if a direction occurred and it was ignored or not followed through by nominees, Limited could have changed the directors. But then if CRL said, well, we don't want you to do that, then they just get rid of the directors on Limited. So it's more how it plays out in practice as to whether there's real power, how it's exercised. At the end of the day, as a wholly owned subsidiary of Headco, CRL, it didn't really have practical power.
Right. And then you also said that it only had one asset. Can you describe for me what that asset is in your terms?
It's either one unit or a series of units in the Burswood Property Trust.
So it held all the units, however many there were, in the Burswood Property Trust. Is that right?
Correct.
It also owned Burswood Nominees Limited.
It had 100% ownership of Burswood Nominees, yes,
It also owned Burswood Resort Management Limited.
which was a subsidiary, I think, of Burswood. I've got the structure here, but I think Burswood Resort Management was a subsidiary itself of Nominees.
Yeah, whichever, whether it was
Well-
through Burswood Nominees or directly from Burswood Limited.
And that's
You
where
know that.
most, if not all, of the employees were.
So, in the sense when you say one asset, we're still talking that somewhere or other in that one asset lay the ownership of all the assets out at the Burswood Casino Complex.
Well, again, you know, the time it became relevant to the directors of Nominees was when there were financing arrangements that involved the asset being essentially the bricks and mortar, if you like, not so much the operating business. So that's when we had some input into decisions around those assets when, you know, banking arrangements were made. But at every other time, the operations, we had, you know, no direct employees. We were informed about the activities, but we had no direct input because we
Okay.
couldn't direct.
So, for me as a commissioner, when I'm directing my mind to who was governing the casino activities out at Burswood, is it right that I am to look at, when I look at Burswood Resort Management Limited, I see that its board did not meet regularly for governance purposes of casino activities?
Well, I
you
wasn't
agree
on
with
that
that?
board, so I don't know how often it met.
So as Burswood Limited, as the parent company of that company, you never looked to see what it was doing at the
Well,
governance level?
As we've said, we were getting regular reports quarterly about the activities of the whole business here, and indeed some that increased over time about the national operation. But as I said, from my point of view, you've got a listed public company with a wholly owned subsidiary in Western Australia. It's not an unusual situation. What is, I think, unusual is that there seems to have crept in that this board had more influence than it did, and it was never set up to have influence. And so what I try and take people to is other national companies that have wholly owned subsidiaries.
Well, let's forget about them. I'm from my point, but, well, no, don't laugh at me, please. I'm looking at the arrangements that were in place here. And can we accept the fact that Burswood Resort Management Limited's board did not meet regularly for governance purposes? Do you agree with that? Or do you not know?
Burswood Limited,
Burswood Resort Management.
I don't know how often that company met.
Do you know how often Burswood Nominees Limited, the licensee, met?
No.
For the purposes of governance?
No, I don't. But I'm assuming that it was quarterly like we met.
And you agree that, well, no, I won't get there, thank you. You express confidence in what the management of Perth Casino told you about the risks of money laundering being appropriately mitigated at the Perth Casino.
Correct.
Do you agree that the board of Burswood Limited was misled by management in that respect?
It was not told all of things it should have been told, whether it was the word misled or omission. It ended up in the same place, that we were not provided with information that subsequently we should have been provided with.
And who do you say is responsible at management at Perth Casino for those omissions?
Well, I've seen the evidence of various people in various places. It would appear that there are two people, Josh Preston and Barry Felstead, who seem to have been the ones that haven't provided enough information, but there are other people in the management chain, people like Ken Barton, who appears not to have provided not only information to us, but to the CRL board either.
In relation to the change in the EGM rules in respect of speed of play, I just want to clarify your evidence about that. Did you know that Perth Casino Management was going to ask GWC to change the rules in that respect before it happened?
I honestly can't recall. I'm trying to remember whether we were informed beforehand. I think it was an issue that had been bubbling along for some time. So on balance, I think I knew before they asked, but I can't recall.
So my next question was going to be, if you knew beforehand, was it that the Burswood Limited board was asked to approve that approach to GWC?
Again, if we were told in advance, it would have been acquiescence rather than approval, in the sense of we are informed that you're going to do this, and we would endorse it.
So would you, in that process, and would you have assumed that they had sought that approval from Crown Resorts?
Absolutely. I can't imagine a situation where the executives of the company would have unilaterally decided to apply for changes to those EGMs without reference to everyone else in the chain of command in CRL. Just can't imagine that would have happened.
And so when you say the chain of command, does that mean at the CRL board level?
The CRL board level, CEO and relevant committees and the management.
Did Burswood Limited have committees?
Burswood Limited had 2 or 3 committees. One was the ERCC, another one was patron,
the patron care committee.
Patron care, and then I think responsible gaming.
So you said in answer to a question from council that in order to look at the governance issues, the governance responsibilities of Crown Resorts, it was only necessary to look at their committees or its committees. Is the same not true of Burswood Limited?
Well, again, it was not set up at any stage in a conventional way. So obviously at a listed public company level, committees are made up of a majority of independent directors. At no stage were any of the non-execs, and I shouldn't really call them non-execs, but the non-management members of Burswood Limited invited to or participate in the committee. So that's unusual.
So the same, your answer to that question would be no, you can't say the same about the Burswood Limited.
Correct.
Thank you, Mr. Poynton.
Thank you, Commissioner.
Mr. Poynton, I've got a few questions for you. Can I start with that, the ambassadorial issue?
Yes.
Now, I'm familiar with the corporate structures that you've mentioned, and you give the example of the Commonwealth Bank, I think, in your witness statement as one where the shared service model comes in.
Indeed.
And I'll come back to shared services in a minute, but you say that the intention was that Burswood Limited really was to be an advisory board on a WA basis, which is a different model again to the CBA model.
Yes. Well, I was involved in the IPO of Bank West, and I recall some of the same provisions, i.e. Perth office must stay in Western Australia, or the head office has to be in Western Australia, and the board of directors. I'm not actually sure what happened after the takeover by CommBank, but that unwound over time.
But if I could just come back to if it were the intention that that Burswood Limited would in effect be a WA advisory board, you would accept, wouldn't you, that may have been the intention, but it didn't happen?
Well, it didn't happen in the way that a normal advisory board, of which I've been on a few, would operate. You're absolutely correct.
So that you would accept that Burswood Limited is a company.
It is a company.
And that directors of that company have the duties that directors have.
Correct.
And I understand your position on what the business of that company is. Now, I wanted to ask you, because I think I may have misheard, so I want to make sure that I understand it. You remember at one stage you were talking about you were asked about the role of the chair, and you stressed the importance of the chair in the governance framework of companies, and that's something with which I agree. A strong chair is vital. But the note I took was that in terms of culture, what you said was that the chair sets the culture and risk appetite, and that permeates through to management. Did I hear you correct when you say the chair sets the culture and risk appetite?
I use those words. In hindsight, it's the chair and the board, but I think because the chair has such a powerful role, whatever culture and whatever is adopted by the board is expressed through the chair and then as they direct the CEO. So I wasn't complete in my answer.
So you wouldn't cavil with what I would think is the more conventional governance theory that culture is set by the board. Culture and risk appetite is set by the board.
In hindsight, that's the better way to put it.
But the chair plays a vital role in getting the board to the point where it can endorse that.
Correct.
Now, this is a general question I'm going to ask you. you've been around this body since 2004. Can I split it into 4 periods? 2004 to 2007, when Burswood Limited was, in effect, a wholly owned subsidiary of the PBL group. It's the first period. The second period is post the PBL breakup, so that's 2007 on. And that's, so it's no longer a wholly owned subsidiary of PBL, but through, I think PBL had 38% or something of CRL, and that then comes down, becomes a wholly owned subsidiary of CRL.
Yes.
The third period is after you became a director of CRL, so that's sometime in 2018.
818.
And then the 2020 period when you are a director of CRL and the chair of, so they're the 4 periods.
Yes.
What I want to ask you is, thinking back now as best you can, did your perception of the role that you were playing, and the role of the companies of which you were directors, did that change from those periods, given the different structures within which you were operating?
I would say that the role didn't necessarily change because of the different structures of the company, and my role changed to the 2 extents you've discussed. I think the company evolved over time, and so there was a period between 04 and 07 where James Packer was much more directly engaged in the aspirations he had for the business in Western Australia. And then when it became more of a conventional wholly owned subsidiary of a listed company with him the chair, for a while, those things moved on, and there was obviously the large investment in towers. But at the same time, that period coincided with well-publicised issues in his own personal life, which led to some appointments being made, which did change, I think, significantly the culture of the company. And it led to a lot of the issues that have been the subject of all the inquiries. And indeed, from, say, the time I agreed to replace him on the board, there was this period of trying to catch up and address these issues that had become evident during that former period, where perhaps he wasn't as involved and where some of the CRL directors, were not as alert to this as they might have been. I don't want to make comment about that, but there was definitely a change in the way the company and its culture carried through that period from, shall we say, the China arrests or just before that through to 20. Unfortunately, when I then became chair here and thought, well, I mentioned before about some of the issues around Mr. Packer's own shareholding and the fact that it was almost inevitable that he was going to sell down or out completely. We had this period of, and we still have it, these rolling closures, the COVID, all the operational issues, which were trying to be managed at the same time in parallel with responding to, the Bergen inquiry, to Finkelstein, to this commission. And the company, back then for me, felt quite under siege. And I thought I could help. Others disagreed. And so I've observed since a serious erosion in value of the company.
All right, thank you for that. That gives me an understanding of your mindset. Now, can I take you to the time when you were a director of CRL?
Yes.
In a broad generalisation, it had 4 theatres of operation: Melbourne, Perth, the Barangaroo development, and the international operations. Is that a fair statement?
Well, the international operations, are they related to the UK casinos, or the international operations as they related to VIP premium?
Well, anything that was was within the purview of the board of CRL.
Right, okay, well, it owned 2 casinos in the UK.
Right.
So that would be what I'd regard as the international business as it related to operations.
Right, so you've got 4 theatres of operation.
Yes.
Now, I hope this doesn't sound too parochial, but from your perception of your time on the CRL board, did you form an impression as to whether the particular interests of the Perth Casino, the Burswood entities, were given proper attention, given the demands on the time of the CRL board and management of those other theatres of operation?
I think with the benefit of hindsight, and we see what's actually happened, that would be a fair observation. And I think it has a bit to do with the fact, as I mentioned earlier, that the investment in the hotel here was disappointing and that the results here were not satisfactory, if you like. So to a degree, it was almost like, you know, we'll turn away from that, and we've got all these other issues. We're trying to develop business and then, of course, walk straight into all the issues with junkets. So to a degree, yes, I think that happened. And the very fact that some of the senior people were spending a lot of time outside of the state managing other things led to it.
All right, now, I want to look to the future, get your assistance on that part of our endeavour, which is looking to the future. And can I come back to the shared services model? Now, don't worry about whether or not there might have to be a breakup. Let's just look at what the situation is. If you accept the proposition, as I think you did, that Burswood Nominees, as the licensee of the casino, has obligations to the people of Western Australia, that Burswood Limited, because if for no other reason than it's a party to the state agreement, has obligations to the people of Western Australia. And then you look at this shared service model and greater degrees, perhaps greater degrees of centralisation of functions that have been in the past. And you ask yourself the question whether this is different to the CBA example that you mentioned in your statement. This is different for the very reason of those obligations to the people of Western Australia. And you can possibly add that it's heightened, depending on the interpretation you put on it, of Clause 3.12 of the Burswood Constitution and also the provisions in the Victorian Casino Agreement. What I'm asking you is the current situation sufficiently bespoke to cater properly for the legitimate expectations of the people of Western Australia in relation to the operations of a casino in their state?
The fact that there's been a problem with the operation of those accounts, Riverbank account, and the fact that the board didn't know about them or that, the fact that there was a barred player playing in Perth, which has not been mentioned, some of those things indicate a problem with the structure. And the question to me is whether one or two things, and I'm not in any way downplaying the situation with Riverbank, but if 99% of the time the operation is fine and it manages to make big capital investments and create employment and do all the right things, then the focus is on more what went wrong and how do we stop that happening again. If in fact at the end of that you realise that the structure is unable to be put right, then inevitably you end up with the need to have stronger oversight in a much more conventional way of the licensee and the operations and the company, and not rely on the efficiencies that come from a shared services model and economies of scale that go with that, with a head office somewhere else.
Right, thank you. Ms Cale, is anything arising?
No, thank you.
Mr Ward?
Thank you, Commissioner. Just before I commence re-examination, that last question, Commissioner, that you put to the witness, and this came up also in Ms Cale's questioning early, put to the witness the proposition that Burswood Limited is a party to the state agreement. Respectfully, it's not. It is an approved company for the purposes of Clause 17A. It is not a party to the agreement.
I stand corrected.
Thank you, sir. Mr Poynton, can I just ask you about one of the questions that Commissioner Owen raised with you about the culture being expressed through the chair? Would you agree? Sorry, I'll withdraw that. In the case of an executive chair, as opposed to a non-exec chair, is that different?
Yes, well, it's different in the sense that that person as an executive has two roles. Is the head of the board, she or he are the head of the board, and they have a role as management, CEO of the enterprise.
In terms of actually expressing the culture,
Well, if you think that a non-exec director is one who can more objectively, in a sense, manage the role than an executive director, then it probably leads you to think that a non-exec is going to be more, in a sense, able to, how can I put it, set the culture from a distant point of, not so much distant, but in a more objective way. Inevitably, with an executive chairman like James Packer, he's going to dominate the board because of his shareholding and the history and everything back in the day when he had more than 40%, for sure. So I do see a difference between an exec chair and a non-exec chair in the setting of and monitoring and maintenance of a culture, but Commissioner Owen is correct. It's actually a board role, but it's expressed in a way in operation through the activities and behaviour of the chair.
can I take you back now to some questions that were asked by Ms Cale? You were shown the consultancy agreement that you'd entered into with CPH, and you recall she took you to the clauses relating to confidential information and made the point that the definition of group in those clauses included both Crown Resorts and CPH. You recall that? Until your attention was drawn to it by Ms Cale, did you ever understand that
No.
that agreement extended to confidential information of
No,
Crown Resorts?
which is obviously an oversight on my part. But I guess what I would say is in operation, and this again came out in Bergen, there wasn't any evidence because there was none to see about any sharing of confidential information. And to that extent, you know, the premise that at least in behaviour I acted independently was something that I was pleased to see.
Can I ask you then to turn to the topic that you were asked many questions about by Ms Cale of audit activities and whether you'd satisfied yourself as to the scope of internal and external audits. Can we please have up documents JHP 001 001 001? And there's going to be a last digit on that, if you just give me a moment to find the last digit. 6.
Better repeat 001.
Sorry, it was JHP 001 001 0016. Thank you. Can we just go back to the first page of that document? So this is the Crown Resorts Limited Audit and Corporate Governance Committee Charter.
Yes.
Do you recall having seen that document?
I have seen it.
And do you recall when this charter was put into place?
Not specifically, no.
Was it before your time joining that board?
Yes.
And you were aware that this charter existed through your involvement before that as a director of Burswood Limited?
Yes.
We go please to to page 16, 0016. Start at the top of that page, please, just everything above 4. Thank you. So in clause 3.6 there, you'll see that the audit and risk, the audit committee is required to review the scope and adequacy of the external audit and annual audit plan. And then in clause 3.8, this committee oversees the process for and receives periodic updates on internal audit processes. Was it your understanding that the scope of internal and external audits that you were asked about by Ms. Cale was being dealt with by this committee?
Correct.
And so when you were taken to the draft strategic internal audit plan, which was document CRW 702 001, just trying to find the first page of that, 2239. So this was the draft strategic audit plan that Ms. Cale took you to before when she was asking you questions about setting the scope of the audit. Where did that audit plan originate from?
CRL.
And this was, if we just go back to the first document in this document, first page in this document, which will be page 2087. This was an attachment to the Burswood Limited board meeting agenda for the meeting on the 8th of August 2014. So did you read that document for that meeting?
I would have.
Can I ask you then, please, to look at the minutes for that meeting, which are document CRL 627 001 0602. And can we go, please, to point 6 on page 6003? The number was CRL 627 001 0602. I wonder if there might be some way we can arrange to produce that, to have it incorporated into the hearing book later, but I can read from it now, if that assists. Point 6 of the minutes for that meeting, if I can just start at the beginning to incorporate the formalities. These are the minutes of a meeting of Burswood Limited, held at Crown Perth on the 8th of August 2014 at 8:30am, and you are listed as one of the directors attending. Under point 6, the heading Internal Audit Report, the minutes record that the report and the Strategic Internal Audit Plan were accepted and taken as read. And that's all that's said about the draft Strategic Internal Audit Plan. Why doesn't that say anything about them having been approved or accepted for implementation?
I don't know. Do each of the minutes refer to the times that those things are put up in the same way, or is it
Well, perhaps I can ask the question in a slightly different way. The strategic internal audit plan that you referred to, you said originated from Crown.
yes?
What was the reason why it was coming through your board?
For information.
And where would it be implemented by?
Well,
who would it
it'd
be implemented by?
As it related to Crown Perth, it'd be implemented through the subsidiaries that actually employed the people and managed or ran the business.
Thank you. Now, can I come back to one of the other documents you were shown? This is a not-for-publication document, GWC .002.0016.0268. Ms. Cale took you to. This is relating to the proposed amendments to the Western Australian appendix for the electronic gaming machines. Put it on there. Do you have that on the screen in front of you?
I do, yeah.
I'll take you, please, firstly, to page. Well, I'll start where Ms. Cale left matters. You were asked about the changes to frequency of gaming and the impacts that might have on harm minimisation. I'll take you to page -0080.
I haven't.
You see at point 8 on the table on that page, there is a column harm minimisation features.
Yes.
And there's no tracked changes in that, indicating this is a proposed change to the determination, which you'll see from the page before.
Yes.
You're not aware, are you, that Crown was ever seeking to alter, Burswood Limited or Crown was seeking to alter its harm minimisation obligations as a consequence of this?
Not at all.
And if I can then take you to page -0083, under the heading Responsible Service of Gambling, you'll see that there are 3 points there that the Commission was asked to take into account. The first of which relates to increasing of state revenue, tourism potential and retention of employment. And it's balanced against other factors. Were you aware of that balancing exercise being considered in the way that Crown built its business plans?
Yes, indeed. In the same way I talked about the junket operations, it's a constant tension. And, you know, the government is leveraged to the outcome of this precinct and this facility because it collects a very large amount of tax. So there's always a shareholder's interest, there's a broader community interest, there's specific interests around harm minimisation, problem gambling, and I've always thought, as it says here, the fact that it's a single precinct to gamble and you have to actually make a conscious decision to go there is a good thing. So yes, it's something that's always balanced in your mind.
And that point you just made about a single precinct, that's really in the second dot point, isn't it?
Yes.
And were you aware in your capacity as a director that there was a low rate of prevalence of problem gambling in Western Australia for that reason?
Not specifically, but it was never raised as some kind of, you know, epidemic as being a major problem.
You weren't aware of it being any worse in Western Australia than
No.
anywhere else in
No,
Australia?
in fact, I would have thought that it was worse elsewhere in places that had many more ubiquitous sort of gambling opportunities like New South Wales and Victoria, in particular Queensland, where pokies are everywhere in the community.
And finally, on that page, under Mr Felstead's signature, you'll see his title there, Chief Executive Officer, Australian Resorts. Where in the structure of the company did that position sit?
Sorry, could you ask that again?
Under Mr Felstead's signature at the bottom of that page, his position title is Chief Executive Officer, Australian Resorts. Where in the Crown Group structure did that position sit?
That reported to the CEO of CRL.
So Mr Felstead, in writing this letter, didn't report, in his capacity as Chief Executive Officer, Australian Resorts, didn't report to Burswood Limited?
No. He was a director of it, but didn't report to it.
Thank you.
And he was a management director, but not an executive director, because there were no executives.
Now, you recall you were asked some questions by Ms Cale regarding the delegation to the Chief Executive Officer to approve the anti-money laundering, to amend the anti-money laundering program. Recall those questions?
Yes.
Can we please bring up document CRW 702-001-1839? Apologies. Again, I'll describe the document and we'll arrange to get it to the Commission to get it incorporated. It is? Oh, thank you. This document, we can go back to the start if necessary. It's an attachment to a board pack, and it's a memorandum from Josh Preston, EGM Legal and Corporate, to Barry Felstead, and refers to the board delegating the authority to make changes to the AML program as required. Do you recall being informed of changes that were made as required?
Only vaguely. I note that this is on the letterhead of Burswood nominees. So, yeah, unfortunately, being 7 years ago, I don't actually recall specifically about it, but it ties in with that previous question.
So, would you expect to have been informed as changes were made through these board packs?
Probably after the fact. There was... I'm still trying to recall the extent to which we were told in advance about applications being made, and I'm pretty sure that we were. And so this evidences that there was a discussion and then so-called delegation. So I have a recollection that we were involved in these discussions, for sure.
Thank you. Can I just go back, to one matter I omitted to ask in relation to the proposed amendments to the EGM determination. Was it your understanding that that was just a proposal and that it was subject to GWC approval?
Yes.
And GWC has to approve every single machine that's...
Yes, it does.
Yes.
And did.
Thank you. You were asked by Ms Cale on that topic of responsible gambling whether you ever inquired into whether some of Crown's advertising was inconsistent with whether you ever inquired of management whether Crown's advertising was inconsistent with its problem gambling obligations, or whether you should have done so, and your answer was no. Why didn't you consider it was your role to ask?
Well, I suppose, again, having been involved in the company for a while, and I'm not sure about the period we're referring to, but we talked earlier about just whether problem gambling was something that was a major issue, and it was never brought to us as being a major issue. We look at other enterprises that advertise their wares, whether they be purveyors of alcohol or other things that might be considered to be harmful. And this comes back to the tension between you running a business that operates a casino and hospitality outlets that is in the business of gambling and recognises its social obligations around harm minimisation. So all these things are always in your mind. And whether you're brought to it as a board member or whether you see advertising out in the community, you're going to be monitoring that. And if you have a concern that it's being too aggressive or has the capacity to make problem gambling worse, you're going to say something about that.
Thank you. Can I now take you to the topic that Ms Cale asked you about relating to junkets, and particularly document CRL 506 007 8870. Ms Cale took you to page 8880 and referred you to the adverse entries in due diligence media reports relating to one of the junket operators. Page 8880, please. Now, you can see there, under those media reports, there were also law enforcement inquiries. There's a reference to VicPol, Victoria Police, 2016 intelligence. Now, these matters, I think you said you were balancing media reports against the fact that Border Force was issuing visas to these people and the Queensland Government had licensed this operator.
Yes.
Accepting that brand is important, when you were looking at these things at that time, did you have any reason to act precipitously to terminate connections on the basis of the media reports or not?
No, in fact, I think over time there have been moves to precipitously stop dealing with people when it became clear that there was evidence that they were criminals or not being allowed, not being allowed back into the country or whatever. So there was an ongoing monitoring of these junket operators.
So would it be fair to say that the media reports were only one thing that was being taken into account?
Media report, given the problem was that there were a number of media allegations all wrapped up together. The company felt that it needed to defend itself and moved quickly to try and do that by way of refutation. Subsequently, in the Bergen report, it's been established it moved too quickly to do that and should have done more analysis on the things that actually were subsequently proven to be correct. What hasn't happened, though, is that some of the things that were proved to be incorrect haven't been referred to much at all, like the accusation that people from Border Force were corruptly engaged with Crown, or indeed other allegations that inferred, people were dealing with Crown who hadn't for some years. So the problem is that on the one hand, you accept that these are serious allegations and need to be addressed. On the other hand, management presents you with evidence that, in fact, a number of them are factually incorrect, which proved to be correct down the track. So you have to balance the reaction that you take, particularly given that your competitors are dealing with the same people. So I'm not trying to make light of the concerns I had about all of this, and indeed down the track, obviously, part of the decision to stop dealing with junkets altogether. But, this is a balance issue. Just one other thing that comes to mind. Late 20 at one of the meetings, there was a piece that can be put up at some point that said Burswood had actually identified somebody, I'm pretty sure it was Burswood, identified someone who'd deposited a whole lot of cash. They'd been reported to the law enforcement authorities and arrested for money laundering. So this contention that the company willfully and consistently turned a blind eye to money laundering is countered by evidence that it didn't do that in that particular case, and indeed presumably in others. So I'm not sitting here trying to defend it, but there's some balance required.
So you were aware, as a director, that there had been instances where the money laundering program had identified and caused matters to be reported and prosecuted?
Yes, and indeed what we were told in board packs regularly, that AUSTRAC was appreciative or WA Pol was appreciative, or we were told in meetings that there'd been action taken, that the police and others were appreciative. So it didn't lead you to a conclusion that the company was actively participating, facilitating, making money laundering easy, because if that were the case, there wouldn't have been any of those kind of actions taken or responses from the authorities. Now, clearly, the Riverbank account is a real problem, and we didn't know about it, and it's been shut down and been the subject of much other discussion. But it's not as if there was an endemic culture of looking the other way.
You were asked, you mentioned AUSTRAC there, you were asked by Ms Cale about the decision to move external audits from 2 to 5 years. And one of the factors that was mentioned in that board minute was that there were AUSTRAC reviews going on. Ms Cale asked you whether you knew, I think the question was something along the lines of, were you aware of what AUSTRAC was looking into, to which you said no. But were you aware generally that AUSTRAC was conducting regular reviews?
Indeed, and we were told that regularly, that there were interactions, there were meetings being held between management and AUSTRAC, and indeed a number of times that the relationship was, viewed positively. Now, we've got to take that minute was written by someone who may well have interest in making us want to believe that, but again, there was no evidence coming through from AUSTRAC to, say, the chair of the company or the CEO that refuted that assertion.
So there are perhaps three elements to this. The first is as to whether AUSTRAC was engaged in the review of the company's AML policies. Were you aware that AUSTRAC was engaged in that?
Yes, and indeed, as I've mentioned, over time, and I'm not sure exactly when it all started, but for, say, the last 3 years or so, there's been at least 3, if not 4, external parties, being Deloitte's, Promontory, Initialism and Dow Jones, all engaged in reviews of, amongst other things, money laundering.
So I describe that as the first phase, the policy. The second phase would be the implementation of the policy, the actual operational work done to comply and implement the policy. Were you aware of AUSTRAC reviewing that activity?
Well, I was aware generally, as I've said, about interaction between AUSTRAC and the company, as evidenced by references to meetings, by working on, improving the protocols and the structure and the whole area around money laundering. And again, no negatives that came from other data sources.
And so the third phase would then be the outputs of that activity, which is the reports to AUSTRAC. Were you aware of AUSTRAC being involved in receiving those reports?
Yes, and indeed then reviews of the work that had been done by these aforementioned external parties, and indeed reference to a question I asked one of them in the middle of 19, I think it was, can you confirm that Crown is best practice? Yes, I can. So again, it wasn't as if we were sitting back listening and not asking.